So again, we're exiting out of this ITP concept and just looking at, okay, what happens when your child turns 18? So for anybody, regardless of whether or not they have a disability, probably any state, but I know for sure in California, but I imagine almost all other states probably operate very similarly. There's a presumption of competence when you turn 18. So you can't legally enter into a contract when you're not 18, but as soon as you turn 18, for some reason, you can magically sign your name and be held liable to a contract, right? For example, that's an example of how the law says when you turn 18, we're going to presume that you are competent to make your own decisions about your own life. This includes educational decisions. So if your student, for example, if your student turns 18 before they graduate, let's say their birthday's in March of their senior year, they turn 18, they could legally withdraw themselves from school and not graduate, and there's really not a whole lot you can do about it, right? They are an adult. They are now competent to make those decisions, and that's the kind of presumption that the law makes. They're going to make that same presumption. Just because they're enrolled in special education, it does not give them a different presumption. The law will still presume competency. And that includes decisions about their IEP. So they are now responsible for making decisions such as consenting to a change of placement, filing or requesting due process or other mediation or other resolution procedures, dispute resolution procedures. It can also be things like, well, do you want this service in your IEP? Do you want this goal in your IEP? They can make the decisions to change those now. They have to sign the IEP. It's no longer you, it's them when they turn 18. Think of all the rights then that transfer. When they turn 18, notifications of meetings will be addressed to them. Consent for evaluations, they consent now. They sign saying, yes, you can perform this test on me, no, you can't. They select who attends their IEP meetings. That means if they're peeved at you, if they're upset with you, they can tell the team, I don't want my mom and dad at the meeting, and you won't be able to attend. They approve the contents of the IEP. It's their signature that says, yes, these changes can be made. And any change of placement, they consent to. So think about what that means. The district can say things like, well, if you don't like this goal, we don't have to do this one anymore. Or if you want to be in an easier classroom, we can change that. You just got to sign right here and we can do that. And I'm not saying districts are going to take advantage of our children in that fashion, but they absolutely can, right? Because our child is now 18 and the presumption is competency. So at least 1 year before they turn 18, the district has an obligation by federal law to notify the individual student as well as the parents that this transfer of rights will occur when they turn 18. And the IEP also has to include a statement that the student has been so informed. So again, at least 1 year before they turn 18, they have to, the IEP is going to say, was the student and parent informed of the transfer of rights upon the student turning 18? Something along those lines. And that's all they have to do is tell you it's coming. So what can you do? Before I get to the other slide, there are formal legal ways, and these are beyond the scope of our class, and it's not something that we do at the Bren Clinic, and it's not something I teach any classes on. But there are legal services for you to gain power of attorney over your child or conservatorship. Those are the terminologies of, and what that means is, and there's a lot to it, but you have to be able to demonstrate to a court that your child is not competent to make the decisions. Again, the law presumes competency upon turning 18. So now you have to go to the court, plead your case, prove to the judge the child who's now an adult or will soon be an adult, that they cannot make those types of decisions on their own. Now, mind you, keep this in mind, my understanding is the bar of competency is very low. So you don't have to prove that they can't make the best decisions. The court's not going to care whether or not the student will make the best decisions for themselves. They're just looking at, will they understand the concepts of what they're deciding? So you may want to talk to different attorneys who do conservatorships on power of attorney and find out if that's something you can do. Okay, so when the student finishes high school, what happens? That's where I talked earlier about they would at least here, we use the terminology of diploma track or certificate of completion. So if they're on diploma track, that means they completed all requirements through grade 12 with passing grades. And remember, D's are passing grades. What they did work on was aligned with the academic standards of the state, and they have met all graduation requirements. If they don't fit in all three of those are ands. So if they can't complete all three of those, check off all three of those boxes, we then would look at, well, they're probably on certificate track then. So that they should have completed their prescribed alternative course of study. That's their ITP. Are they still working on those adult outcome goals, or have they achieved them, right? So are they still working on their ITP and IEP goals? If they're still working on those, then they have not completed their prescribed course of study. Or have they participated in instruction as prescribed in their IEP and met objectives of the Statement of Transition Services? So this is looking specifically at the ITP. If we've got the adult goal of I can get and keep a job at Wendy's, and they have a job at Wendy's, then maybe they're ready to get their certificate of completion because they've met that adult outcome objective statement within their transition services. And so the district no longer needs to help them because they've got the job and they've held it down for a little while now, and then looks promising. When you get a diploma, the district no longer has to provide any special education services to you. Wow. Now, if you don't get a diploma and you stay on this certificate track because you didn't meet the requirements for a diploma, you can continue receiving special education services as long as you're eligible up through the age of 22. So when you turn 23, you're no longer eligible for special education services anymore. Okay. The district doesn't have to continue providing any services at that age either. So it depends on how you exit out. You may exit out because you got a diploma, or you may exit out at the age of 22. And those are the two primary ways of exiting disability, right? Their disability is probably not as severe. So the assumption there is they have they can have goals that are a little bit more difficult. Okay. If they're on certificate of completion, maybe they're not quite ready for the level of difficulty of those goals, but we still need adult outcome oriented goals. So the legal scope is the same, regardless of which track they're on. Okay. But we have to individualize the ITP to the needs and abilities of the student.
Okay, thank you.
And